And once you're in that sort of system of law, you've basically abandoned a legal project. You've abandoned the rule of law. You've abandoned non-racialism. You've abandoned equality. It's one of the reasons why in the Supreme Court of Appeal, the Rule of Law Project, who I acted for, intervened and said we need to be able to talk about this double standard problem, that you cannot have a situation where some groups are given full license and others have to walk on eggshells all the time. That's not what our legal framework envisages. Interesting enough, there's one exception. So there's a case I ran against Valapi Kamalo. So Kamalo had said we should do to white people what Hitler did to the Jews. They should be burnt alive, hacked to death, and their children turned into garden fertilizer. And so the Human Rights Commission brought a complaint. I acted for them in it. And Judge Sutherland, who wrote the judgment for the Equality Court, said you cannot have different rules for different races.
Yes.
That whether you are an ascendant group or a minority group or a powerless group or a powerful group, the law applies to you equally. And you cannot have a sense in which some people are given greater protections than others. And that sort of line of thinking has been picked up in some directions, but it seems to have been roundly ignored in the Kildeboer case.
And this goes to that Human Rights Commission finding in 2019, which was very alarming, in which it basically said that the ruling by the Human Rights Commission saying that you need to consider the race of the person that is being accused in determining whether it's hate speech or not.